Good morning, and thank you for joining us for our very first KPHR workshop of 2021. We're excited to kick things off this morning. Yesterday was a big day. We brought in our 46th president, so very relatable to the topic for today, which is going to be what is the Biden administration, what does that mean for employers? So we're going to get into that in just a moment. We do have two guests with us today. Those of you that have joined us in the past understand that we have a phenomenal partnership with MidAtlantic Employers Association. So we have Amy McAndrew here. She's the Director of Legal and Compliance. She's going to be taking us through our presentation today. And we also have Maria Bonelli, who's the Regional Sales Director for MEA over here in New Jersey. So I'm going to just quickly kick it over to Maria just to do a short introduction to herself and who MidAtlantic Employers Association is.
Good morning, everyone. Thanks for joining us. And I I hope many of you recognize me and our relationship that we have with Katz Pierz. So MidAtlantic Employers Association, otherwise known as MEA, just as a very quick introduction, we are a membership-driven organization for employers. We have over 650 members, so that's 650 employers who are members with MEA, and we help them with everything from HR needs, legal needs, talent acquisition. So it's a great organization that helps your company and helps your employees. So thanks for joining us this morning.
Thanks, Maria. And those of you who do not know who I am, my name is Christy Magnotta, Director of Client Engagement here at Katz Pierz. Katz Pierz is a employee benefit firm located in Cherry Hill, New Jersey. In addition to focusing on employer health plans for companies of all sizes, we are very highly focused on employee advocacy and education, as well as helping our fellow HR partners and administrators in the crazy world that we live in today and all things HR related and help supporting them. Part of the reason why we partnered with MEA back in 2019, and they really have been such a great partner for us, both internally here at KP and for our many clients that are members of the organization. So without further ado, I'm going to go ahead and kick things over to Amy to get us started. Just a few housekeeping items. If you do have questions, please feel free to put those into the chat box. I'll be monitoring those, and hopefully we will be able to get to all of your questions at the end of today's presentation. So with that, Amy, it's all you.
Great. Thank you, Christy. Good morning, everybody. As Christy said, my name is Amy McAndrew. I'm Director of Member Legal Services here at MEA, and I'm an attorney by trade, employment attorney. I've been doing this a really long time, 25 plus years. So I've seen many changes in administrations. And I think what we will be able to see, what my sort of theme of the day is going to be is remember the Obama administration. I think that's a lot of what we're going to see from the Biden administration. Now, of course, we're in a pandemic, which makes things a lot different. It changes the context of things, but it certainly is part of the theme when we're talking about various things. So let's sort of dive into it. And this is especially true if you were in an HR type position or running a company back in the late 2000s when President Obama was in office. Remember the Employee Free Choice Act? There was a lot of activity around that law. President Obama had been supported by unions throughout his campaign and had made a lot of promises, and he tried to pass legislation that was called the Employee Free Choice Act, also known as EFCA. Would have made it much easier for unions to organize, would have cut down the amount of time between a petition being filed and the election itself, the union election itself. What's important about that? Most employers find that once they educate their employees, once they run a campaign and give their employees information, in most of those cases, the employer is going to win the election. So if you can cut down the amount of time between petition and election, cut down the amount of time that an employer has to educate its employees, it's more likely that the union is going to win. So Employee Free Choice Act did not pass, but there were some changes that were made largely by executive order. And there are now shorter times for elections. It is a little bit easier for unions to organize, but we may very well see another push under the Biden administration to make union organizing even easier. Biden has described himself as a union man. As I'm sure you know, he's from Scranton, Pennsylvania, which at one time was a union stronghold. So I fully expect that he is going to show the love and show the support for the unions by trying to help them in any way that he can. He certainly has expressed, President Biden has, that he thinks that the economy is stronger, the nation is stronger when unions are strong, and union membership in the private sector is way, way down, below 10%. So I fully expect to see some movement in the union realm. Now, the other important thing, though, a lot of you might be saying, well, you know, I'm not a unionized organization. I don't have any real concern about a union coming into my workplace. But what we saw under the Obama administration, that even non-union employers were affected by some of the changes that took place at the National Labor Relations Board. So the National Labor Relations Board, which enforces the National Labor Relations Act, which is something we usually think of when we think about a union environment, also is applicable in the private sector non-union environment, okay? The National Labor Relations Board is made up of 5 members. Currently, we have 1 vacant seat, 1 Democratic appointee, and 3 Republican appointees. One of those Republican appointees' terms will expire this year, which means by the end of calendar year 2021, when we fill that seat, or when Biden fills that seat and fills the empty seat, I fully expect that we will have a Democratic majority on the National Labor Relations Board. So again, this is harkened back to the Obama administration. What we saw was the National Labor Relations Board really trying to make itself relevant in the non-union sector, and was handing down rulings left and right about various policies that employers could and could not have. And it really got kind of to the ridiculous at some point. We saw policies such as you can't defame your employer being struck down by the National Labor Relations Board as violating the National Labor Relations Act. So just kind of keep your eye on that, keep your pulse on that. We at MEA will continue to talk about this if it becomes an issue. A lot of times we see pendulum swing, especially around employment law issues with the change of administration. This definitely could be one of those situations. So think about your workplace, right? Think about whether or not you might be at risk for union organizing. And a lot of you might be thinking, oh, why is she so anti-union? So as I said, I spent most of my years working in private practice, and I'm certainly not anti-union, but I do think that unions oftentimes make a lot of promises that they can't keep, and oftentimes just become kind of an entity that gets in the way between the relationship between an employer and its employees. And what I've found over the years is that an employee is less likely to turn to a third party. And when I say third party, that could be a union, that could be the government, right, going to report you to the DOL or to OSHA, or just going to an attorney. But they're less likely to turn to that third party when they believe that you as an employer respect the law, respect your own policies and procedures, respect the employees, and you treat employees consistently and don't play favorites. And I think, you know, we're in a tough time right now. Some employers are just trying to survive. Some companies are just trying to survive. And the ones that are may not have the most happy workplace right now, right? Again, just trying to get by. So I think it's a good time to look at your workforce, to look at the rules that you have in place, to look at how you're applying the rules, and make sure that you are doing everything you can to have a workforce that is committed to you and loyal to you, and it's not going to turn to one of those outside third parties again, whether it be a union, whether it be going to the government to complain about you, or whether it be going to a lawyer and saying, I want to file a lawsuit against my company because I don't think I'm being treated fairly. So at a minimum, in the union context, you want to look at your non-solicitation, non-distribution policies. One of the ways that unions get in is that they hand out literature, and handout could be a physical handout, it could be an electronic handout, but you want to make sure that you have policies that prohibit that kind of distribution. Okay. Now that's tough because you can have the policy, but how do you put it into place? Because if you let your employees sell Girl Scout cookies, right, or do that fundraiser for their kids' sports team, that's generally speaking going to violate your own non-solicitation, non-distribution policy. And now you have to let the unions do the same thing. So take a look at your policies, take a look at your practices. This may not be as applicable right now in a pandemic, but take a look at your visitors policy. Who are you allowing on site? Who are you allowing to have access to your employees? Also a good time to do a salary and benefits review. Again, I know some employers are just trying to get by right now, just trying to survive. But if you are one of those lucky businesses that is doing well right now, think about how you can include your employees in that success. Are you consistent with the market with regard to salary and benefits? And if you're not, consider making some changes. And really just a good time for an overall handbook review. As I said, National Labor Relations Board may be coming after you, may be coming after all of us with regard to some policies. So take a look at your policies, take a look at your procedures. Is there anything in there that's questionable, that might be vulnerable? Anything that you took out during the Obama administration, then you put back in during the Trump administration. And then manager training, especially if you think that you're at risk for union organizing. It'd be a good time to make sure your managers know what they can and can't do, because there are some pretty significant rules around what managers can and can't say to your employees and what they can and can't do. So think about some manager training as well. Keep in mind that can be done virtually if that's a concern. Okay. So we probably will have a more active National Labor Relations Board. I'm thinking also a more active Department of Labor. Okay. I'm sure you've heard by now that the current mayor of Boston, Marty Walsh, has been selected as President Biden's potential Secretary of Labor. He is a former union head, so it's not hard to see where his leanings may be, okay? I think at a minimum, what we're going to see is a federal minimum wage hike. That's been talked about for years and years, and it's never happened. Federal minimum wage is still $7.25. It's higher in New Jersey, but remains $7.25 in Pennsylvania. So the push would be for a $15 minimum wage. I'm sure we're going to get a lot of pushback from the business community on that, but I fully expect some sort of compromise. And it'll be phased in. It's not something that'll kick in all at once, but I won't be surprised if we get a $10+ dollar minimum wage at the federal level. Expanded pay equity laws, okay? There's been a lot of discussion about this for years, mostly at the state level. New Jersey and Pennsylvania have strengthened their pay equity laws. And I expect to see that on a federal level as well. We could see a change in the law. It's a fairly non-controversial idea, right? That people of different protected classes, so men and women, people of different minority groups, and Caucasians should be paid the same amount for the same work. But to put it into a more formalized statute, to make it easier for plaintiffs to prove these cases in court, something I think that we're going to see. And then the two other things that I have more slides on to talk more about, the FLSA salary threshold and worker classification. All right, so let's talk about the FLSA salary threshold. FLSA is the Fair Labor Standards Act. It is the federal wage and hour law. Keep in mind that states also have their own wage and hour laws. So when I'm talking about these thresholds, New Jersey and Pennsylvania have their own thresholds. Pennsylvania currently mirrors the federal threshold. New Jersey is a little bit higher. But for an employee to be exempt, and that means exempt from overtime, they don't get overtime no matter how many hours they work per week. For an employee to be exempt, they have to meet two tests. One is a duties test, and that's specific to each type of exemption. But the other one is a salary threshold test. They have to be paid on a salary basis, and they have to make a minimum amount of money. Okay, simple enough, right? In 2004, the salary threshold was set at $455 a week, so $23,000 and change. In 2016, the Obama administration said that number is low, and it's been low for a long time. We want to raise the number, but they got a little bit too ambitious, in most people's opinion, and they proposed the raise to $913 a week, about $47,000 and change. And the other kicker was that there were going to be automatic increases every 3 years. Well, it was inching closer and closer to being implemented. And if you remember this, if you were in an HR capacity or dealt with wage and hour issues back during this time frame, you may remember some employers actually instituted changes in their workplace because of this change that was coming down the pike. And then some of them ended up regretting it, unfortunately, because what happened just before this was going to go into place, it was stricken down by a federal court judge in Texas. And the Obama administration did start to fight it, but then the Trump administration came in and they stopped that fight. So it remained, so the threshold remained at $23,000 and change. Then in 2017, the Trump administration basically compromised. raised the threshold to $684 a week, so $35,000 per year, and $35,000 and change per year, and no automatic increases. And that's the current threshold that we live with. The business community seemed okay with that. They didn't challenge it. So now what, right? It's anticipated that Biden may try to up this number again, may try to go back to the Obama number of $47,000 and change per year, and or do that automatic increase. And to me, the automatic increase is even a bigger deal, because that obviously will change for years and years to come, unless or until another administration comes in and changes it. So another thing to be thinking about. And then another really big deal under the Obama administration was worker misclassification. So many employers use independent contractors in their workforce, and many employers grapple with the exempt versus non-exempt distinction. So I'm going to talk about both of those. And this becomes important, especially in a bad economy. So back in 2009, what we saw from the Obama administration, and let me back up a second. One of the reasons it becomes so important in a bad economy is because governments are looking for tax revenue. And so imagine right now during COVID, how many government entities have lost out on tax revenue, either because people are not working at all, or because they're working in places that are different than where they used to work. I mean, you think about Philadelphia's tax base with the city wage tax for employees who are working from home and not in the city. So a lot of governments are looking for places to get tax revenue, and they were looking for that back in the Great Recession, that 2009, 2010 timeframe, and that's when this worker misclassification thing became a really, really hot topic, especially the independent contractor versus employee situation, because it wasn't even just that private attorneys were filing the lawsuits; it was the government coming after employers. So let's get a little bit of background information. So what's an independent contractor? So typically, an independent contractor is not a regular part of your workforce. It's someone who's engaged only for a term required to perform a certain task, a certain service, a certain project. The independent contractor, that worker, is supposed to retain control over their method and manner of work. They retain their economic independence. They are responsible for paying their own taxes, and they're not protected by a lot of federal or state employment laws. The contracting entity generally has the right to control the end result of the work, right? I can tell you, tell a worker, I want this room painted a certain color blue, but I don't tell and I need it done within 2 weeks, but I don't tell the worker when exactly that needs to get done or exactly how to paint. I don't give the worker the supplies to do the painting. The work just gets done. So I control the end result, but I don't control the method or the manner of how it gets there. Many, many benefits to using independent contractors, as many employers know. Independent contractors are not covered by a lot of employment laws like FLSA, Family Medical Leave Act, Title VII of the Civil Rights Act of 1964, although the Pennsylvania anti-discrimination law does cover independent contractors. The New Jersey law does not. Also ERISA, many OSHA provisions, and the National Labor Relations Act. So from an employer's point of view, it's pretty great to have independent contractors when you can. Generally speaking, it's going to cost me less money. I don't have this legal exposure, tax benefits, benefit savings. I don't have to offer my independent contractors health insurance, and certainly increased workforce flexibility. An independent contractor is not on my payroll every day of every week of every year. There's someone who can float in and out as I need them to get certain tasks done. Okay, so let me back up because I'm moving to the other part of this next. So the issue then becomes, are your folks properly classified as independent contractors? There are many, many different tests here that different courts use. It is entirely possible, and some people anticipate that the Biden administration is going to come up with one test that will be applied on a federal level. But a lot of times what it comes down to is control. So if you have people in your workforce who are kind of working side by side your regular employees, but you're just calling them independent contractors, or if you have people who you really control the work, control how they do the work, give them the tools to do the work, they probably are independent contractors. And now you're exposing yourself to private causes of action and also the government coming after you. And like I said, I think the government coming after us is going to be heightened under a Biden administration. Time to probably look at that. The other issue is this idea of exempt versus non-exempt. Okay, an employee can be exempt, as I said, from the overtime requirements of wage and hour law if the job meets certain standards. It's really important to categorize these folks properly. I've talked to plenty of employers who've said, no, everybody in my office is exempt, virtually impossible, okay? We have common white-collar exemptions. I'm not going to go through what all these mean, but the executive and administrative exemption are what apply to most employees in most workforces who are properly classified as exempt. We also have professional outside sales and computer employees. But at a minimum, you have to meet a duties test, and like I said before, you have to meet that salary test, right? So beware of misclassification, whether it's exempt versus non-exempt, or whether it's independent contractor or employee. Remember, the law decides what the proper classification is. It's not up to the entities involved. So even if a worker signs an independent contractor agreement, even if an employee says, yeah, I want to be exempt, it really doesn't matter. The law is ultimately going to make that decision. Not to mention the fact that one of my sort of tenets of HR law is everything is okay until it's not, right? So a lot of times employees or workers will be happy with a certain categorization, but then something changes. They're not happy. You know, the independent contractor who all of a sudden is not getting 40 hours of work a week is going to decide that this is a problem for me, and I'm either going to go to the government or I'm going to go to a lawyer, okay? So like I said, enforcement's been down under the Trump administration, but we fully expect that the IRS, the Department of Labor, and of course, state counterparts are going to start making this a priority again, if for no other reason than to fill the tax coffers. Okay? So take a look at it. Again, if you use independent contractors, now would be a great time to look at those relationships. If you have thoughts that maybe some of your employees who are exempt maybe really should be non-exempt, it's a good time to look at it. You know, one of the reasons that employers tend to freeze over these issues is because they don't know how to make the change. But a change in administration can sometimes provide cover for that. You know, we've had a change in administration, we've had a change in the way the law is being applied, and therefore we're going to make this change. And a lawyer can certainly help you message that in addition to making the changes. Okay, so examples of missteps, I won't go through all of these, but various situations where employers got themselves in trouble over significant amounts of money for misclassifying folks as independent contractors. And then I've got another slide, similarly, misclassification of exempt versus non-exempt. And keep in mind that while sometimes you get one employee who sues you, a lot of times what happens is these are class actions. You've got a group of employees who are misclassified either as exempt versus non-exempt, or a group of workers who are misclassified as independent contractors. They band together, they file a lawsuit, and that's why these numbers tend to be so big. So something to think about. All right, sort of the next category of what might change under a Biden administration, paid time off. So we've seen New Jersey has a paid sick leave statute. Philadelphia has a paid sick leave ordinance. The thought is, and President Biden ran on this in part as part of his platform, that he would like to implement paid time off and paid sick leave on a national basis. So the part that we don't know is how many days, how will it be earned? When can they be used? Will this be for all employers, just larger employers? It's not clear. The guess is that it would be a lot like New Jersey statute. You would earn time, so maybe an hour for every 40 hours worked or an hour for every 30 hours worked. I've seen both in various state statutes with a cap usually, and that it can be used not just when somebody's sick, but also for preventative care and also to care for a family member. So stay tuned on that. There also has been some discussion on paid family leave. Again, you guys have a version of this in New Jersey already through the state insurance funds, but it may be that this ends up on a federal level. Stay tuned on this. And it's not clear, again, will this just be large employers, will this also be smaller employers? And how's it going to get paid for? Will it be a payroll tax that then the state administers, or it will be an expectation that the employer pays and maybe get a tax credit? So stay tuned. I think we'll see some of this introduced within the first six months to a year of the Biden administration. And keep in mind also the Biden administration wants to take advantage of the fact that they have a Democratic majority barely in the Senate in both houses of Congress, right? So they're going to want to try to push through as much of this slightly controversial stuff as they can early on. Now, the other part of this is the Families First Coronavirus Response Act. As I'm sure most of you know, FFCRA paid leave provisions, the mandated part of it, the part that mandated that employers provide FFCRA leave expired on December 31st. The expectation was that this would get extended. I think everybody expected it would get extended, but it really did not become a priority with everything else that Congress had going on. But now President Biden has proposed an extension. So just to back up for a second to make sure we're all on the same page, the Families First Coronavirus Response Act, FFCRA, was instituted very early on in the pandemic. It was for private employers with less than 500 employees. There was a small exemption for small employers, 50 or less, but it wasn't much of an exemption. Really, the expectation was if you were less than 500 employees, you were giving this leave and you were getting it paid. And in exchange, the smaller employers were getting, or all employers with less than 500 employees would get a tax credit. Okay, so there are two components to this FFCRA leave. There's an emergency paid sick leave, 10 days, the equivalent of 80 hours of paid sick leave when the employee can't work or telework for these 6 enumerated reasons. And that's they're subject to a quarantine or isolation order. They've been advised by a healthcare provider to quarantine. They're experiencing symptoms of COVID-19 and seeking a diagnosis, caring for someone who's subject to quarantine, or the issue with the schools having to care for a child who either their daycare provider is closed or their school is closed or unavailable. The 6th one, still no one knows what this means, so I won't even cover that. But that was kind of the catch-all I think they were putting in there just in case they needed it. So that was the 10 days of paid sick leave. And then there was an emergency expansion of the Family and Medical Leave Act only for school closures or daycare closures, all right? And now, at the end of the year, the tax credit was extended, but not the, like I said, not the mandated piece of the leave. So you as an employer can make a decision that you are going to voluntarily extend and go for the tax credit. And this is just through March 31st. But keep in mind, if you're going to voluntarily extend, you have to voluntarily extend it to everybody. You can't just say, oh, I like Joe, so I'm going to give him the leave. I don't like Mary, so I'm not going to give her the leave. Extend it for everybody. And there are some, just to sort of backtrack a little bit, there are some interesting things about that. If an employee has already used the 80 hours of leave, they don't get a new 80 hours of leave, at least as of right now. And any time used under the emergency expansion of FMLA counts towards regular FMLA. So kind of interesting. But now Biden gave a speech last week where he's proposing to extend it and expand FFCRA. So he wants to, first of all, expand the covered employers. All right, but basically cover everybody. Because I think a lot of folks said, why are only employers with less than 500 employees being covered by this FFCRA? And the explanation that Congress gave was, well, we expect larger employers to do the right thing. And I think some of them have and some of them haven't. So this would expand to cover all employers, but only the smaller employers would be able to get the tax credit. So kind of a win-win for employees and still a win for smaller employers. The proposal is also to increase the amount of leave and the amount of money being paid. So this would be 14 weeks of paid sick time and family medical leave, and it would expand the reasons for the leave. I think some people were concerned under FFCRA that the categories of leave were unnecessarily narrow. I think part of that was just because we were at the very beginning of the pandemic and we didn't really know exactly what our employees would need. So I think that's why some of the language is a little bit limiting. But this would increase the amount of leave. This would increase the reasons for leave and also more money. The maximum paid leave benefit would be up to $1,400 per week. So for many, many employees, that would be full reimbursement of their wages. All right, so that's FFCRA, that's paid leave. How about marijuana? So, and this is interesting, especially in New Jersey, because you guys, the voters in New Jersey said, yes, we want legalized recreational weed. The legislature is still figuring out exactly how to do that. That legislation hopefully will be passed sometime soon, but it may in some ways be taking a little bit of a backseat to the pandemic right now. So pre-pandemic, when I talked to employers, one of the biggest conundrums that they had was around marijuana and what to do about it, especially in states where they had legalized medical marijuana, so Pennsylvania, New Jersey, Delaware, but didn't have recreational weed legal and still illegal under federal law. And that's kind of the key, because what a lot of employers hung their hats on that, right? So even if marijuana is legal under our state laws for some reasons, we could always fall back on the position that it was illegal under federal law. And there's been a lot of confusion, especially in a state where you've got medical marijuana is legal, but maybe recreational weed is not. Is it allowed at work? Is impairment allowed at work? What level of impairment? Are certain positions or tasks and eligible for medical marijuana use, and when can an employer test? So the answer to that is, of course, we don't. In a lot of ways, marijuana is becoming more and more like alcohol, right? So we don't have to allow use at work, and we don't have to allow impairment at work, right? But the problem, what makes marijuana different than alcohol, is it's hard to tell what impairment means. With alcohol, we have pretty good testing, whether it's breathalyzers or blood or urine, to tell how much alcohol someone has in their bloodstream at a given moment in time so that we can judge impairment. Unfortunately, marijuana doesn't work that way. And I'm not a medical expert, but I've had enough cases where I've dealt with this, that apparently THC just stays in the system. THC is the active ingredient that gets one high in marijuana. That stays in the system a very long time. And if someone is a chronic user, it stays in the system even longer. So if you've got somebody using medical marijuana, and yes, medical marijuana generally does have THC in it. If it didn't, you wouldn't have these issues. That's why it becomes so hard to judge impairment at any given moment in time when someone is at work. Even with a blood test, which you don't usually do blood tests as part of a workplace analysis, even with a blood test, it can be hard to tell if somebody is currently impaired. So, and what level of impairment counts, right? What's the right level to be looking for? Certainly, most employers have taken a position with regard to safety-sensitive positions. If I've got somebody working, if I've got somebody driving, if I've got somebody working with electricity, if I've got somebody working on heavy machinery, I don't want them to be impaired by any stretch of the imagination. So they've taken a harder line when it comes to marijuana use. And when can you test? So the fallback position on this has been, for a couple of years now, you can't discriminate. Well, first of all, you can't discriminate against someone for merely holding a medical marijuana card. But at the same time, you don't have to tolerate impairment at work. And so it has become more and more important over the years for employers to offer training to their managers on what reasonable suspicion is and when you should be testing someone, okay? Because what you want to do is you want to have someone who's exhibiting signs of impairment at work coupled with a positive test, and then an employer has felt much safer in taking action against that employee. So if you have a workplace where you have concerns about marijuana, think about reasonable suspicion training for your managers. It really is a good idea, especially for those of you who still are out there and still physically coming to work every day. But it could get very interesting depending on what happens under a Biden administration, because like I said before, the fallback position has always been, well, it's illegal under federal law. And the expectation is, especially sometime in the next 2 years when we have a Democratic majority in Congress, that we may try to, or the government may try to decriminalize marijuana, change the way it's categorized under the various laws, and that could be a real game changer in how employers deal with it. So, think about it. If you run a call center, is marijuana a big deal to you? Probably not. Whereas, like I said, if your employees work with electricity or they're driving or work with heavy machinery, maybe it is. So something to certainly think about, okay? And then other likely changes, definitely immigration changes coming down the pike. President Biden has already announced what those might look like. Some of them not as applicable to employers, an extension of the DACA or a reinstitution of the DACA program, making it easier for people who are currently in the country without legal status to get legal status, but also probably an expansion of the foreign workers programs and visas. One of the things we saw the Trump administration cut back on was allowing foreign workers into the countries, giving out visas. So if you're an employer who has relied on foreign workers in the past, we're not going to see this open up immediately, obviously, because we remain in a pandemic. But I think you can expect there to be changes. We at MEA actually have an amazing immigration partner, an attorney at Buchanan, He's coming to speak for us in a couple of weeks at one of our the webinars that we run regularly to talk more about immigration changes. So I think it's a welcome relief for a lot of employers who have relied on foreign workers. Certainly a more active OSHA. I think it was surprising to a lot of employers that we saw so little activity from OSHA during a pandemic. But I think you can expect to see much more enforcement now, much more regulation now to happen soon. Like I said, Marty Walsh, the current mayor of Boston, is expected to be, he's been expected to be confirmed as the Department of Labor Secretary. And I think we'll see more activity around OSHA. So certainly if you have a safety person, something for them to be paying attention to, make sure you tighten up and make sure you're following all the safety regulations that you can. Another thing that I think we'll see is a limiting use of restrictive covenants. We've already seen this movement around the country from various state legislatures, movement on this. There's always a concern in a bad economy about employees being able to have access to work. And the last thing that we want from a government point of view that the government wants is for employees to not be able to take a new job because they have a restrictive covenant, or to not have job mobility because their employer has a non-compete. So we've seen the cutbacks, like I said, from various states over the years, and now we might see this on a federal level as well. So that's something to look at. If you use restrictive covenants, if you use non-competes, what you really want to concentrate on is what's your legitimate protectable interest, and does your agreement hopefully limit itself to that protectable interest? So, think about it from an employer's point of view. What you may care most about is your trade secrets, right? Your secret sauce. So having confidentiality agreements in place might do a lot of what you're looking for. Or have limitations with regards to contacts with current clients or customers. So it's not so much that I tell you you can't go work for a competitor, but when you do go work for someone else in the industry, you can't contact all of your old customers, all of your old clients. So think about those types of restrictions rather than the sort of traditional, you can't work for 2 years in this industry within 100 miles of us. And the 100 miles thing has gotten old anyway in the internet age. But a lot of employers just still have these old blanket, you can't go work for a competitor for 2 years. And most of the time that's not going to fly currently. And if there could continue to be change in the law, that's definitely not going to fly. So it might be a good time to look at your restrictive covenants. Do they still make sense in the current environment? How can we change them to make them more reasonable? Because judges want to see reasonableness when they're going to enforce these. And definitely Affordable Care Act changes. I think after ACA was passed, there was a pretty broad agreement that it was not a perfect piece of legislation by any stretch of the imagination. I think there were some attempts to fix it during the Obama administration, and those kind of fell by the wayside because Congress wasn't willing to help around those changes. And so Trump came in, the Trump administration came in and kind of chipped away at ACA. But I think what we're also seeing is that a lot of people like ACA, right? It has done some good stuff. So the hope is that a Biden administration can come in and fix it, kind of make some necessary changes to fix it. I know there is concern that we move farther to the left and we get Medicare for all or something similar to that. But I think the first step is probably going to be trying to fix the Affordable Care Act. People have asked me, do I think the individual mandate will come back? I mean, it is kind of the thing that makes the whole thing work, right? You want to get the healthier, younger people into the fold and paying premiums in order to support the other folks. That's how insurance works. But I'm certainly not an insurance expert. So I think stay tuned on that. Talk to your broker about that. Have those conversations. What do they see coming down the pike? Are there any changes that you should be making to your plans to anticipate that? Okay, so that was sort of a very quick down and dirty. Christy, do we have any questions?
As of right now, we just have one, and it goes back to the piece around medical marijuana. So the question is, does testing an employee for marijuana use in states where medical marijuana is legal, does that pose any possible HIPAA violation?
Not a HIPAA violation. I mean, but what you want to have first, there are privacy concerns, not HIPAA. And keep in mind that most employers are not actually covered by HIPAA. I know everybody thinks they are. Most of the confidentiality concerns for employers actually come from the Americans with Disabilities Act. So to go off on a tangent for a second. So when we think about a COVID positive employee in the workplace, everybody says, oh, am I violating HIPAA if other people find out that this person was positive? No, but you might be violating the Americans with Disabilities Act. But the important thing around testing is you got to have a policy, because there are privacy concerns. There are state law privacy concerns. So if you're going to test, have a policy, distribute the policy, have your employees sign off on the policy, whether that's signing off on receipt of the handbook or just signing off on the individual policy, because there are different types of testing, right? There's the offer testing, right? You give an offer, somebody goes for a drug test. There's random testing. And that means truly, truly random testing. Most employers who do random testing use an outside third party to pick who's going to be tested on any given day. It's not just, oh, Joe walks in today, I don't like the way he looks, I'm going to test him. And then there's reasonable suspicion testing. And that's the one that most employers really want to have. And there's also post-accident testing, which is a good idea depending on the workplace that you're in. So if you are running heavy machinery, if you run a warehouse, you really want to have the ability to post-accident test. But reasonable suspicion is the one where you put a lot on your managers, on your supervisors, to be able to tell who's impaired and who's not. And that's why training for your managers becomes so important. And there is formal training out there. MEA does it. I'm sure plenty of other places do it. If you want to be doing reasonable suspicion testing, especially in the current environment around marijuana, get training for your managers.
Yeah, I think that that was kind of the theme throughout the presentation, is to really kind of make sure your managers are aware of certain aspects, especially as things maybe start to change, that and updating your policies and your handbooks to reflect any type of changes that are happening or may be coming down the pipeline in the future. So with that, it doesn't look like we have any other questions. I think you did a fantastic job, and you probably addressed everything, and that's why we don't have a lot of questions right now. I think a lot of us are just interested in seeing what's going to happen over the next few years, and we'll be watching that closely. So, with that being said, I guess we're going to wrap up a little bit early. Amy, thank you so much again for your participation in our workshop. And we definitely are looking forward to our next workshop, which I believe is coming in May, but that's to be determined. And we will definitely be sending out some correspondence when we get a little bit closer to that. For those of you that are interested in either speaking with MEA directly or joining one of their webinars, like Amy had mentioned, please feel free to reach out to me. I am happy to get you guys in contact and get you onto their list to make sure that you guys are included in any of those really wonderful webinars that they put out on a consistent basis.
Yes, and our webinars are open to non-members as well, so anybody can join.
Perfect. Well, Amy, Maria, thank you so much, and we hope everybody stays well.
All right, take care.
Bye.
Thanks.